Hi world, welcome to Brian A. School of Law, your go-to place for your legal knowledge and needs irrespective of jurisdiction. Welcome to Lesson 8, wherein we are going to review Chapter 10 of Kenya's Constitution, which pertains to the judiciary. We're going to see the judicial authority, we're going to see the system of the courts, the structure of the courts, as well as the Chief Justice and etc. Let's get right into it. Chapter 10 on Judicial Authority. Judicial authority, this is the power that the court system has, and this power is derived from the people of Kenya and will be exercised by the courts and tribunals established under this constitution. Judicial authority should be exercised in a manner which is guided by the following principles. Justice shall be done to all, irrespective of their status, whether rich or poor, and regardless of whatever status you are in the society, justice must be seen to be done and be done as well. Justice shall not be delayed. Alternative forms of dispute resolution, including reconciliation, mediation, arbitration, and traditional dispute resolution mechanisms shall be promoted. Not just everything should be taken to court, but rather there are those disputes which can be resolved at a lower level. Justice shall be administered without undue regard to procedural technicalities. Where you fail to keep a certain procedure due to honest oversight, those technicalities must not impede justice. The purpose of the principles of this constitution shall be protected and promoted. This is by all persons as well as the court system. When it comes to the traditional dispute resolution mechanisms, they shall not be used in a way that contravenes the Bill of Rights, in that those dispute mechanisms which are traditionally employed, like the Baraza za Wazee, should keep in mind the Bill of Rights as provided for in this constitution. Those mechanisms should not be conducted in a way that is repugnant to justice and morality or results in outcomes that are repugnant to justice and morality. They should be in keeping and have justice and morality in mind. As well as those mechanisms, those traditional mechanisms must not be inconsistent with this constitution or any other written law. Independence of the judiciary, judicial authority shall be subject only to this constitution and the law. The office of a judge of a superior court shall not be abolished while there is a substantive holder of that office. The remuneration and benefits payable in respect of judges shall be a charge on the consolidated fund. We shall talk about the consolidated fund later. And the remuneration, that is the payment and benefits payable to a judge, shall not be varied to the disadvantage of that judge, as well as the retirement benefits of a retired judge shall not be varied to the disadvantage of that retired judge during the time that that judge lives. A member of the judiciary is not liable in an action or a suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. In that, a member of the judiciary, or maybe a judge, for example, is not liable in action or to be taken to court in respect of anything he did or she omitted to do in good faith. The word to understand there is in good faith in the lawful performance of a judicial function. Judicial officers and officers, the judiciary shall consist of the judges of the superior courts, that is the Supreme Court and the Court of Appeal, the High Courts, and then the magistrates courts, which are the chief magistrates courts, resident magistrates courts, senior resident magistrates courts, and we shall look at this shortly, and other judicial officers and staff. There is established the office of the Chief Justice, who shall be the head of the judiciary, or the president of the judiciary. The Deputy Chief Justice, who shall also be the deputy head of the judiciary, and the Chief Registrar of the judiciary, who shall be the chief administrator and accounting officer of the judiciary. The system of courts. The superior courts are the Supreme Court, the Court of Appeal, and the High Court. The Parliament shall establish courts with the status of the High Court to hear and determine disputes relating to employment and labor relations. And here we have the employment and labor courts already established. And another court with the High Court status to hear and determine matters of the environment and the use and occupation of and title to land. And so we have the environment and land courts already. The superior courts, as we have said, this is the Supreme Court, the Court of Appeal, and the High Court. And there is established the Supreme Court, which shall consist of the Chief Justice, who shall be the president of that court, the Deputy Chief Justice, who shall deputize for the Chief Justice, and the Vice President of the court. So the Deputy Chief Justice will be the deputy or deputize the functions of the Chief Justice in the absence of the Chief Justice, and shall also be the Vice President of the Supreme Court. And then it shall constitute of 5 other judges. The Supreme Court shall be properly constituted for purposes of its proceedings if it is composed of 5 judges. So if the Supreme Court has 5 judges and above, it has quorum. If it has less than 5 judges, the Supreme Court cannot sit, in that the proceedings will not be valid. The Supreme Court shall have exclusive original jurisdiction to hear and determine disputes relating to elections of the office of the President. And the meaning of exclusive original jurisdiction means that this court, the Supreme Court, in matters to do with presidential elections, has the power to take evidence and to hear that evidence for a sound determination of the case. Original jurisdiction means the court has the power to hear and take evidence, and if necessary, ask questions on the facts of the evidence in order to come to a determination. It should be distinguished from appellate jurisdiction, and appellate jurisdiction means that the court only has powers to hear appeals from the other courts out of matters of law only. It does not have the authority to take evidence in a matter if it is on an appellate jurisdiction. Rather, it relies on the evidence which was taken by the court from which the appeal emanates. If the court with the appellate jurisdiction seeks further information on the evidence, it will refer the matter back to the court from which the appeal emanated, for that court to take evidence and then submit it to the Court of Appeal. Good. The Supreme Court shall also have appellate jurisdiction to hear and determine appeals from the Court of Appeal. We've spoken about the appellate jurisdiction. And to hear also appeals from any other court or tribunal prescribed by national law. Appeals shall lie from the Court of Appeal to the Supreme Court as of right, in any case, in that if you have a matter in the Court of Appeal and the matter goes against you, you shall have the right to appeal to the Supreme Court. And that right comes involving the interpretation or application of this Constitution. So if it is something that you want this Constitution to be interpreted in order to satisfy a certain facet of your case, you shall apply to the Supreme Court for that interpretation. And appeals shall also lie from the Court of Appeal to the Supreme Court in any other case in which the Supreme Court or the Court of Appeal certifies that it is a matter of general public importance. So if it's a matter of general public importance, and that's how it is certified by the Court of Appeal, and the Supreme Court also certifies it, then the Supreme Court shall hear that appeal. And if the Court of Appeal asserts that a matter is of public importance, the Supreme Court may either affirm it or vary it or overturn it. So Supreme Court has the final and ultimate authority. The Supreme Court may give an advisory opinion at the request of the national government or any state organ or any county government in matters concerning the county government. In that if there is a section of the law which is not clear in any matter concerning county governments, the Supreme Court may give an advisory opinion on that. And then all courts other than the Supreme Court are bound by the decisions of the Supreme Court, in that the Supreme Court shall be the highest in judicial precedent. If you remember lesson 1 of the introduction of the law, we spoke about horizontal and vertical judicial precedent. So the Supreme Court is at the topmost. This is the apex court. And all its decisions will bind other small courts. But the lower courts shall be bound by the Supreme Court's decisions, but the Supreme Court will not be bound by its own decisions. The Supreme Court shall make rules for the exercise of its jurisdiction, and we have these Supreme Court procedure rules. The Court of Appeal, this shall consist of the number of judges being not fewer than 12, as may be prescribed by law, and shall be organized and administered in the manner prescribed by an act of parliament. And we already have this. We have this act that governs the Court of Appeal. There shall be a president of the Court of Appeal who shall be elected by the judges of the Court of Appeal. So the judges themselves from the Court of Appeal will appoint their president. And the Court of Appeal has jurisdiction to hear appeals from the High Court and any other court or tribunal as prescribed by an act of parliament. So the High Court is established under Article 165 of the Constitution, which shall consist of the number of judges prescribed by an act of parliament and shall be considered and administered in the manner prescribed by an act of parliament. Again, we shall look at that act. There shall be a principal judge of the High Court who shall be elected by the judges of the High Court from among themselves. So the High Court judges will elect a principal judge of the High Court from amongst them. And the High Court has unlimited original jurisdiction in criminal and civil matters. Again, as we said, original jurisdiction, the High Court can take evidence and hear that evidence and ask questions as pertaining that evidence in criminal and civil matters. The jurisdiction is the authority to determine the question whether a right or fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened is also a mandate of the High Court. The jurisdiction to hear an appeal from a decision of a tribunal appointed under this Constitution is also the power of the High Court. The jurisdiction to hear any question respecting the interpretation of this Constitution, including the determination of the question whether any law is inconsistent with the interpretation of this Constitution, is the duty of the High Court. In that, if a law has been passed by the legislature, that law appears to be inconsistent with this Constitution, then the High Court has that power to interpret that law. The High Court shall also determine the question whether anything said to be done under the authority of this Constitution or of any law is inconsistent with this Constitution. And any matter relating to constitutional powers of state organs in respect of county governments, and any matter relating to the constitutional relationship between the county government and the national government shall be interpreted by the Constitution, as well as a question relating to conflict of laws shall be interpreted by the High Court. And the High Court shall also have any other jurisdiction, original or appellate, that will be conferred on it by legislation. The High Court shall not have jurisdiction in respect of matters reserved for the exclusive jurisdiction of the Supreme Court under this Constitution. The High Court has supervisory jurisdiction over the subordinate courts and over any person, body, or authority exercising a judicial or semi-judicial function, but not over superior court. In that, the High Court shall supervise how the lower courts or any person or body or authority which has judicial functions like a tribunal are working. But the High Court shall not supervise the Court of Appeal or the Supreme Court because they are high. Appointment of the Chief Justice, Deputy Chief Justice, and other judges. The President shall appoint the Chief Justice and the Deputy Chief Justice according to the recommendation of the Judicial Service Commission and subject to the approval of the National Assembly. And also the President shall appoint all other judges in accordance with the recommendation of the Judicial Service Commission. And each judge of a superior court shall be appointed from among persons who hold a law degree from a recognized university, or are advocates of the High Court of Kenya, or possess an equivalent qualification in a common law jurisdiction. Each judge shall also possess the experience required, irrespective of whether that experience was gained in Kenya or in another Commonwealth common law jurisdiction. And the judge must have high moral character, integrity, and impartiality. The Chief Justice and other judges of the Supreme Court shall be appointed from among persons who have at least 15 years of experience as a Superior Court judge. I repeat, the Chief Justice and other judges of the Supreme Court shall be appointed from among persons who have at least 15 years experience as a Superior Court judge, or at least 15 years experience as a distinguished academic, judicial officer, legal practitioner, or such experience in other relevant legal field. Each judge of the Court of Appeal shall be appointed from among persons who have at least 10 years experience as a Superior Court judge, or at least 10 years experience as a distinguished academic or legal practitioner, or such experience in other relevant legal field. And each judge of the High Court shall be appointed from among persons who have at least 10 years experience as a Superior Court judge or professionally qualified magistrate, or at least 10 years experience as a distinguished academic or legal practitioner, or such experience in any other relevant field. The tenure of office of the Chief Justice and other judges: a judge shall retire from office on attaining the age of 70 years, but may elect to retire at any time after attaining the age of 65. The Chief Justice shall hold office for a maximum of 10 years or until retiring, whichever comes earlier. If the Chief Justice's term of office expires before the Chief Justice retires, the Chief Justice may continue in office as a judge of the Supreme Court. The Chief Justice and any other judge may resign from office by giving notice in writing to the President. Removal from office: a judge of a Superior Court may be removed from office only on the grounds of inability to perform the functions of office arising from mental or physical incapacity, a breach of a code of conduct prescribed for judges of the Superior Court, bankruptcy, incompetence, or gross misconduct or misbehavior. The removal of a judge may be initiated only by the Judicial Service Commission acting on its own motion or on the petition of any person to the Judicial Service Commission. A petition by a person to the Judicial Service Commission shall be in writing, setting out the alleged facts, constituting the grounds for the judge's removal. The Judicial Service Commission shall consider the petition, and if it is satisfied that the petition discloses a ground for removal of the judge, shall send the petition to the President. And the President shall, within 14 days after receiving the petition, suspend the judge from office, and acting in accordance with the recommendation of the Judicial Service Commission, in the case of the Chief Justice, shall appoint a tribunal. That is, if the Chief Justice is the one to be removed from office, the President shall appoint a tribunal consisting of the Speaker of the National Assembly, who shall be the chairperson of that tribunal, 3 Superior Court judges from common law jurisdictions, 1 advocate of 15 years standing, and 2 other persons with experience in public affairs. In the case of a judge other than the Chief Justice who is supposed to be removed from office, the President shall appoint a tribunal consisting of a chairperson and 3 other members from among persons who hold or have held office as a judge of a superior court, and 1 advocate of 15 years experience standing, and 2 other persons with experience in public affairs. And that tribunal shall be responsible for the regulation of its proceedings, subject to any legislation, and that tribunal shall inquire into the matter expeditiously, that is speedily, and report on the facts and make binding recommendations to the President. A judge who is aggrieved with the decision of the tribunal may appeal against the decision to the Supreme Court within 10 days. The subordinate courts, we have the magistrate courts, the Qadis courts, and the courts martial, and any other court or tribunal as may be established by law. The Qadis court, there shall be a chief Qadi, in such a number being not fewer than 3 of other Qadis as may be described by the Act of Parliament. A person shall not be qualified to be appointed to hold or act in the office of Qadi unless the person professes the Muslim faith. So the Qadis court, these are courts to hear and determine interpersonal matters between Muslims, and possesses such knowledge of the Muslim law. So you must profess the Muslim faith and possess such knowledge of the Muslim law. The authority of a Qadis court shall be limited to the determination of questions of Muslim law relating to personal status, marriage, divorce, or inheritance. So if it comes to things of Muslim personal status like marriage, divorce, or inheritance, those cases go to the Qadis court. But if it is cases like murder, a Muslim has been involved in murder or any other criminal act, those cases go to the High Court. Establishment of the Judicial Service Commission. There is established a Judicial Service Commission. The commission shall consist of the Chief Justice, who shall be the chairperson, 1 Supreme Court judge elected by judges of the Supreme Court, 1 Court of Appeal judge elected by judges of the Court of Appeal, and 1 High Court judge and 1 magistrate, 1 a woman and 1 a man, elected by members of the Association of Judges and Magistrates. The Judicial Service Commission shall also compose of the Attorney General, 2 advocates, 1 a woman and 1 a man, each of whom has at least 15 years experience, elected by the members of the statutory body responsible for the professional regulation of advocacy, that is the Law Society of Kenya. And also 1 person nominated by the Public Service Commission, and 1 woman and 1 man to represent the public, not being lawyers, appointed by the President with the approval of the National Assembly. And the Chief Registrar of the Judiciary shall be the Secretary to the Commission. The functions of the Judicial Service Commission shall be to recommend to the President persons for appointment as judges, review and make recommendations on conditions of service of judges and judicial officers other than their payments, and review and make recommendations on the conditions of service of the staff of Judiciary. The JSC shall also appoint, receive complaints against, investigate and remove from office or otherwise discipline registrars, magistrates, other judicial officers, and other staff of the judiciary. The JSC shall also prepare and implement programs for the continuing education and training of judges and judicial officers. And the JSC shall also advise the national government on improving the efficiency of administration of justice. And in performance of its functions, the JSC shall be guided by the following. 1. Competitiveness and transparent processes of appointment of judicial officers and other staff of judiciary, and the promotion of gender equality. The Judiciary Fund is established, which shall be administered by the Chief Registrar of the Judiciary, and the fund shall be used for administrative expenses of the judiciary and such other purposes as may be necessary for the judiciary to discharge its functions. And each financial year, the Chief Registrar shall prepare estimates of expenditure for the following year and submit them to the National Assembly for approval. On approval of the estimates by the National Assembly, the expenditure of the judiciary shall be charged on the consolidated fund, and the funds shall be paid directly to the Judiciary Fund. Good. And dear class, as we said, these classes will be brief, straight to the point. And that was the third arm of the government we've looked at, the judiciary. In Kenya, the judiciary is seeking its independence from the executive. And we know there have been pleas from the Chief Justice David Maraga to have that independence as enshrined in this constitution upheld by the executive. We are waiting to see how that goes. Remember, if you missed all the other classes that build up to this video lesson, subscribe to this YouTube channel, watch and like those videos, be empowered and share widely so that you can also empower another. And as I say, love one another, for that is the only way you will be able to keep the laws of the land as well as the laws of God. Till next lesson.